In my experience, an issue that is often of concern to Embassies, High Commission and Consulates is whether their workers are employees or contractors, and that's what we'll be looking at in the next part of the presentation. And it is certainly quite right that organisations are concerned about this difference, because it is quite important. One of the reasons is that employees are entitled to a range of legislatively guaranteed benefits that contractors are not. Things like the minimum employment standards, coverage under awards that we spoke about earlier today. Employees are also protected by the Fair Work Act 2009 and can therefore bring claims for unfair dismissal or adverse action against an employer, whereas contractors cannot. As we have also spoken about in the presentation today, employers have certain taxation and superannuation obligations in respect of their employees that they do not have in respect of contractors. Therefore, very important to determine whether your workers are employees or contractors. So what are the essential differences between an employee and a contractor? Well, firstly, and perhaps most obviously, employees enter into an employment agreement, whereas contractors sign a contract for services. However, that is not the end of the matter, as the courts have found when examining whether a worker is an employee or a contractor. Particularly, in the matter of Porter, the court said the parties cannot create something which has every feature of a rooster, but call it a duck and insist that everybody else recognise it as a duck. So the essential point being, what you call something is not the end of the inquiry, and simply calling someone an employee rather than a contractor does not necessarily make it so. Rather, the courts will look at a range of factors to decide whether a worker is truly a contractor or an employee. Let's have a look at some of those factors now. Firstly, the court will examine how much control an employer or organisation has over the individual. So, for example, to what degree an employer can stipulate how a particular task is done, the hours that a worker is required to be on site. All of these matters of control will go into the mix in deciding whether an individual is an employee or a contractor. The more control, the more likely the individual is to be characterised as an employee rather than a contractor. Secondly, courts will look at whether the individual has the ability to perform work for other people, or whether they work exclusively for the employer or that particular organisation. Exclusivity of work will more likely indicate an employee rather than a contractor. Whether the individual has a separate place of work will also go into the mix, as will whether the individual advertises his or her services to the world at large. If they do, they're more likely to be a contractor if they're advertising their services. Who owns the tools or equipment used to do the work will also be one of the factors that's examined. If an individual owns their own tools or equipment, more likely to be a contractor rather than an employee. Whether work can be delegated will also be looked at. Who has the right to suspend or dismiss the individual? How the worker presents to the world at large. This can be something as simple as what they have on their email signature. If their email signature makes it clear they're a contractor, they're more likely to be found to be a contractor. Whether withholdings are taken from the individual's payments and paid to the tax office. If they are, more likely to be an employee. Whether the person is paid by a wage or salary on a regular basis, or is paid at the completion of a task. If it is at the completion of a task, then the individual will be more likely to be a contractor rather than an employee. If a person has paid holidays or sick leave, more likely to be an employee rather than a contractor. If the work involves a profession, trade or distinct calling, will also go into the mix. as will who pays for the person's insurance, whether the worker creates goodwill, and whether the worker spends a significant portion of the worker's payments on business expenses. So no one of these factors is determinative. Rather, the courts will look at the relationship as a whole, taking all of these factors into account to come to a decision about whether a worker is an employee or a contractor. It is in those finely balanced situations that it can often be useful to get some external advice. It's certainly something that I have a great deal of experience in advising on, and particularly in relation to the operations of high commissions, embassies and consulates,